I'm saying, but I was not going to say anything against him.
Yes.
I don't know why, but
No, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use, maybe infected as of now. But
So, any form of religious instruction would ex facie be barred in AMU by virtue of the provisions of Article 28(1).
madrasa or Gurukul, for both, my lord, I'm saying, without receiving any aid, you impart religious education, not the religious instruction. No difficulty.
You're not accepting that position. Your position is if it's wholly funded by the state, then number one apply, clause 1 will apply. Be careful what you're saying, it may have repercussions.
I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You said don't. I don't want to interrupt, and then you interrupt.
ability in court, please.
My lord, I'm sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
argument.
Your lordships would come in, my lord.
Let's 1 second.
No, my lord. Your
1 second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
yes, my lord. This is unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal. Yes, just 30 seconds.
On the day when the emergency argument was, I was only going to make a historical reference, Mullah. I was sitting in court when the Attorney General of India, Nirande, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying, but I was not going to say anything against him.
Yes.
I don't know why, but
no, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use, maybe infected as of now. But, my lord, I'll say, your lordship, the distinction is, Nirende was not, my lord, in a situation where one high court had struck it down and the provision was not on the statute book.
yes, the
Here,
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
there were other high courts which have upheld, and there is all your lordships are aware, Mr. Nirende told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Nirende, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that you have. This is the position. Please interfere.
Mr. Solicitor General, let's come back to the point. Your
Yes.
argument is that 1981 amendment, you need not to comment for the simple reason that by virtue of a judicial verdict, this provision has been erased from the statute book.
Correct.
That is what you want.
It
we can
doesn't
now-
exist as of now. I leave it at that, my lord. I will not, my lord, be uncivilized in my lord arguments. Now, my lord, please come to Mr. Sibal is generally not, my lord, but
51, this was a religious, this institution was maintained wholly by state funds.
may not be done, may not be wholly.
No, wholly we'll have to exclude small little fees, etc. But it was,
Otherwise, yes.
it was wholly.
Yes.
In fact, it is your argument that
Yes,
it was
yes.
wholly.
They were having some minor.
So there is a bar on providing religious instructions in institutions wholly maintained by state fund. Now,
Correct.
2.
It expressly allows for religious instruction in AMU, subject to the consent of those who are receiving religious instruction. Now, under what provision of Article 28 does this proviso to to Section 8 fall? If you look at the first clause of Article 28, the first clause of Article 28 interposes a complete bar, right? See Article 28(1).
No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
Now, it is maintained out of state funds. For a moment, we'll take it on the basis that it is wholly maintained out of
Correct,
state
Manoj.
funds. So, any form of religious instruction would ex facie be barred in AMU by virtue of the provisions of Article 28(1). Now, Article 28(2), Clause 2 lifts the bar to a certain extent.
Except,
Right.
for two exceptions,
Right.
yes.
Now, where does it lift the bar? Let's read 28(2). Nothing in Clause 1 shall apply to.
I'll read, Manoj, Your Lordship, please, no. Shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
And now what does 3 do? That no person who attends such an institution, a state-aided institution, will be compelled to undergo religious
Can
instruction unless the parent or guardian has consented. This puts the requirement of consent. So clause 2, then otherwise there would have been an absolute bar under clause Article 28(1). What clause 2 of Article 28 does is to lift the bar. In the case of an institution which may be otherwise administered by the state, but which has been established under an endowment or trust which requires that religious instruction shall be imparted in such institution. So,
Two doesn't apply in facts
the
of.
proviso, perhaps, the proviso to Section 8 is in recognition of, is an implementation of the provisions or is pursuant to the provisions of Clause 2 of Article 28. But for Clause 2 of Article 28, that proviso would have run afoul of Clause 1 of Article 28. So that proviso comes in as a result of Clause 2 of Article 28. Now, when it comes under Clause 2 of 28, it's in recognition of the fact that this is established by a trust or endowment, which requires that religious instruction has to be given or imparted in such institution.
So the
That possibly
government
may be
is
the position.
kind of bound by the covenants of that, my lord, trust or
The endowment
endowment.
or trust.
Yes, it is an agnostic provision. It applies to minority as well as non-minorities.
Correct.
So even if it is a minority institution or non-minority institution, one says
It
if it is wholly,
It introduces the character of secularism in education.
yes. And three kinds of take a middle path that all right, if you wish to, you provide, but don't compel. And even in case of a minority, my lord, academically and constitutionally, it is possible that a minority institution, say Hindu, the Muslim minority institution, may say that we will provide religious education both in Hindu studies and Islamic studies. What they cannot do, they cannot compel the students. So it is, my lord, the
3 is a provision which is against compulsion. What 3 does is basically to create an option. That's why 9 came to be deleted, really speaking in that sense.
Exactly, I'm obliged.
9 was deleted. Because
Simultaneously.
9 provided for compulsory religious instruction to Muslim students.
Yes, therefore.
Now, after the deletion of 9, it's not that religious instruction is done away with, but all students, Muslim or otherwise, have now a choice.
He may be therefore an exception to both 1 and 2. Read it carefully.
Another very important aspect of 3 is 3 applies even if you are not wholly maintained out of state funds. Because 3 merely says receiving aid. Receiving aid may be 5%, 10%, whatever. Once you are receiving any aid, then 3 applies.
Or,
1 applies, 1 is wholly out of state funds.
so meaning thereby, if you have a madrasa or a gurukul, for both, my lord, I'm saying, without receiving any aid, you impart religious education, not religious instruction, no difficulty. But the moment you start accepting something from the government, constitution steps in, and whether,
This will be important. Just read 3 once again.
yes, my lord, no person attending any educational institution recognized by the state
So 1 requirement is recognized by the
Recognized.
state. Number 2 is,
or receiving aid out of the state fund shall
now
be.
here the words are not used wholly funded by the state.
Correct, my lord, yes.
Any aid received by the state.
Not
So
wholly.
If not wholly. So if we read it as an exception to one, then it may be permissible even for wholly funded state institutions to impart religious education.
Not wholly.
You're not accepting that position. Your position is if it's wholly funded by the state, then number one apply, clause one will apply. Be careful what you're saying. It may have repercussions.